The value of recording interrogations. In order to protect the integrity of their work, investigators should record their interviews and interrogations. Oftentimes, defendants will claim that their confessions should be found inadmissible because they were not advised of their rights, they did not understand their rights, they asked for an attorney but were denied, the investigator physically harmed them in some way, they were threatened that if they did not confess, they would never see their family again, or they claimed they were promised that if they did confess, they would get counseling instead of having to go to jail. They were not allowed to use the washroom or have something to eat or drink over a period of several hours, or that they were under the influence of drugs or medications at the time they confessed, or some such similar claim. The value of recording the interview and interrogation of the subject is to be able to disprove these claims. Our website is replete with case examples of courts reviewing the recording of the interview and interrogation and concluding that the defendant's claims had absolutely no basis in fact whatsoever. Here are just a few examples. Januziak versus Cooper. The court noted that the interview session was lengthy, approximately 7 hours including breaks, but noted that Januziak did not appear to be overtired or unable to exercise her free will during the interview. The court found that there were at least a couple breaks in the questioning and that the officers offered Januziak food and drink during the interview. Commonwealth versus Gillette. The judge found that Gillette appeared calm, was responsive to the questions, and displayed well-organized thinking and rational decision-making on how to respond. Patrick versus State. There was no glaring behavior that would have led a reasonable judge or jury to believe that Patrick was under the influence of any drugs or alcohol or manifesting any drug withdrawal symptoms. Indeed, while tired and distressed concerning his crimes, Patrick seemed intelligent, reflective, and engaged during the interview, even drawing a map for the interviewing officer to show where he left the victim's keys while providing detailed instructions. Torres versus State. The video recording of appellant's custodial statement shows no evidence of intimidation or coercion, nor physical or psychological pressure to elicit statements from appellant. In this particular case, it appeared to me like this was a real tragic event that occurred, and my impression was appellant couldn't wait to get it all off of his chest. He wanted to say what he was saying, let everybody know what had happened. State versus Baker. Although the defendant only completed the 8th grade, the DVD demonstrates that he answered police questions readily and responsively, unless he reasonably wanted to think about the question and his answer. He displayed no signs of any inability to understand questions or to respond appropriately to any given question. State versus Gray. The trial court noted that defendant at no time appeared incoherent. Rather, he was lucid, talkative, and expressive, and was able to give detailed information in response to the detective's questions. Further, the trial court noted that it did not see evidence of any fragmented thought process or incoherent answers, nor any indication that defendant did not comprehend the questions or was somehow impaired by any medication that may have been administered to him at the hospital. Further, as noted by the trial court, defendant was lucid and gave coherent and detailed answers to the detective's questions. Moreover, there is no indication that defendant was sleeping during the interview or affected by any type of medication. State versus Gomez. The court notes that the Miranda rights were read to the defendant in Spanish. There was testimony that the defendant's first language is not Spanish or English. There was ample testimony that he speaks the Spanish language and some of the English language. The court notes that at no time during the interview that was conducted in Spanish and English did the defendant indicate that he could not understand either the interpreter or the law enforcement officers. In fact, to the contrary, the defendant would, when asked a question by the police officer, not hesitate to correct or clarify his answer, even when it was contrary to the officer's question. These are just a few cases out of many that illustrate the value of recording an interrogation to protect the integrity of the investigator's work. However, it should also be noted that the recording of an interrogation can also point out when investigators do not act properly. For example, Rodriguez versus McDonald. The higher court stated the following: that videotape and transcript rebut by clear and convincing evidence the state court's factual determination that the detectives honored Mr. Rodriguez's invocation of his right to counsel, a factual determination that on the record before the state trial court was unreasonable. In this case, it is undisputed that Mr. Rodriguez invoked his right to counsel. The videotape and transcript of Mr. Rodriguez's interview constitute clear and convincing evidence sufficient to rebut the state court's factual finding that the detective honored Mr. Rodriguez's invocation of his right to counsel by immediately ceasing their interrogation. There is tremendous benefit to be gained by recording a subject's interview and interrogation. It should be considered a best practice for investigators to electronically record their interviews and interrogations. For more information on this topic, visit our website at read.com and our book, Criminal Interrogation and Confessions. Thank you for taking a few minutes to view this presentation.